Welcome to the Citizens Band Radio Hour. Thoughtful conversations that explore issues of media and journalism, democracy and citizenship. The Citizens Band Radio Hour is sponsored by the Center for Media and Citizenship at the University of Virginia. You can visit the center online at mediaandcitizenship.org. Here's your host, Coy Barefoot.
Brandon Garrett is a professor of law at the University of Virginia. His research focuses on the criminal justice system, exploring lessons learned from cases where innocent people were exonerated by DNA tests, research on false confessions, forensics, eyewitness memory, and the difficult compromises that prosecutors reach when targeting the largest corporations in the world. Garrett's books include Convicting the Innocent, Where Criminal Prosecutions Go Wrong, and Too Big to Jail, How Prosecutors Compromise with Corporations. This conversation with Brandon Garrett took place at the studios of WTJU on grounds at the University of Virginia in February of 2016. Brandon Garrett, welcome to the Citizens Band Radio Hour.
Thank you. It's great to be here.
The subjects and the topics that you explore in your book, Too Big to Jail, we're seeing that on the campaign trail right now. The race for the White House in 2016, they're talking about these issues of how do we deal with criminal corruption among major corporations, especially in the financial industry.
Yeah, I did not expect when I first started studying this stuff, back in 2005, 2006, that it would be a hot political topic, how we prosecute corporations in this country. Because it used to be that corporate prosecutions were kind of a backwater. You didn't normally go after the company, since there are a lot of ways of finding companies. You don't need a criminal prosecutor to do that. And when they did start to really prosecute companies somewhat more often in 2003 or so, they did it in such a lenient way with these deferred prosecution agreements that were out of court. That one reaction that people had was, okay, so we're prosecuting companies now, but they're not serious. They're negotiating these things out of court. It doesn't really look like criminal justice. And so I started documenting that and analyzing it. But really when the financial crisis hit in 2007, all of a sudden it became a national topic that, wait a minute, the things that happened on Wall Street, the dealings between different financial institutions may have brought the global economy almost to the edge of a cliff, and we're all suffering because of it. And what is the criminal accountability going to be? Is it going to be another one of these deferred prosecution agreements? Are any actual executives or bankers going to be prosecuted? All of a sudden, this became a big question of, this is one of the many ways that the 1% gets treated differently. Is it that they're immune from criminal prosecution? And so all of a sudden, I called this book Too Big to Jail. And I had things happen like the Attorney General at the time, Eric Holder, makes a speech saying there is no such thing as too big to jail. The banks are not immune from prosecution. It's not true. And so I was not expecting this topic to explode in the way that it did. But now, once again, it's at least among the Democrats, it's a real topic of concern. I don't think I've heard any of the Republicans talk about the need to prosecute corporations.
If you follow this story, I'm hard-pressed to find some truth in what Holder says. If it's true, then, Eric Holder, where are the prosecutions?
Well, okay, so let me stick up for the Department of Justice here, because I genuinely admire the work that federal prosecutors have done to try to step up their enforcement against corporations, although I'm also a leading critic of what they've been doing. But for starters, there is no country in the world that does anywhere near the kind of corporate criminal enforcement that we do. Other countries are thinking, wow, maybe we should think about, I was just reading a report out of Ireland, maybe we should start doing deferred prosecution agreements. Or when I was giving talks in England last year, we've never had $1 billion fine against a corporation ever. And you're criticizing what they do in the U.S. We don't prosecute any corporate crimes really. The Serious Fraud Office was always called sort of a serious joke in England. And so everyone in the world is looking to what U.S. prosecutors are doing as a model. And yet when we look at what they were doing, we're comparing it, our prosecutors are some of the most powerful individuals in government. And yet what we've seen is out-of-court deal after out-of-court deal. Now, in their favor, what they can say is, we are bringing bigger cases than ever before. every year, and it's true because I've collected the data, and it takes a long time to collect. I just finished analyzing the 2015 data. Every year they've collected more billions of dollars in fines from corporations and prosecutions than they have before. So last year it was over $9 billion in corporate penalties, which broke the records from the year before, which broke the records from the year before that. The first $1 billion fine in a criminal case in American history was just a few years ago, a case involving Pfizer. And so, you never saw $1 billion cases. In the 90s, a big case, a big criminal prosecution for antitrust violations or price fixing would be like, a $30 million fine, a $10 million fine. So they can say, we're bringing in the money. We're bringing in the penalties. That's changed. We never did that before.
That's the good news.
That's the good news.
I guess one question would be, though, is that for a corporation, has that just become a cost of doing business? That, hey, if we get caught or if the feds come sniffing around, we're going to lose a certain percentage of these profits that we're making. Does it deter criminal activity? Does it deter corruption?
Yeah. So I begin my book by describing, yes, there's been this stunning rise in the size of the penalties paid. The big household name companies are now being prosecuted. They never were before. Eric Holder is right that we are now prosecuting banks. We didn't prosecute them before. But then I debunk my own data and ask, well, what do these fines even mean? They're about 5 different too big to jail concerns. One is even just focusing on the money aspect. Is it just a cost of doing business? And when you look at these fines, they're often a fraction of what they could have been, even under the applicable criminal sentencing guidelines and statutes. And often it may be a fraction of what the company profited in the criminal scheme itself.
Exactly. Yeah.
And so not only maybe it's typically for the public companies I found it was less than 1% of their market capitalization, so it's small in terms of their larger business. But then the question is, but what do they make specifically from this criminal scheme? And often, at best, they are giving up their profits. And you'd think, well, yes, of course you should have to. That's a sort of a basic rule of criminal forfeiture in federal court that, yes, you have to give up your illicit gains. You can be fined, though, up to twice the gains or up to twice the loss to victims under an alternative fines provision. It is rarely invoked in these corporate criminal cases. But you think, well, that's a punishment. If you have to pay more than what you got, that'll deter you from doing it again.
But they don't do that.
Instead, normally when a guidelines calculation is provided, and it's incredibly non-transparent, often it'll just be a round number. This company is paying $400 million for committing serious tax or bribery or fraud, whatever it is, violations. And you think, well, where does 400? Is 400 million a lot or a little? I mean, it sounds like a big number. But often when they provide a calculation, they explain that actually 400 million is below the bottom of the applicable guidelines range. And then maybe it's more sensible for them to just not explain at all, so you have no idea what that number means.
Let me throw out a silly comparison, and you tell me if I'm right. I'm picturing a bank robber who steals $1 million, and the feds say, "You know what?
Give it back.
We caught you. We're not going to put you in jail. We're going to ask you to fork over $200,000 of that $1 million, and you can keep $800,000." And then they go before the cameras and say, "We're fining this bank robber $200,000," but they don't tell you that they're letting him keep $800,000 and nobody's going to jail.
Well, even if they say, yes, he had to give back the entire $1 million, it's different if it's not a bank robber, but it's a corporation where you figure, okay, so part of their business was bank robbery, and you're making them return the money the one time you caught them? How about all the times you didn't catch them? That's the sort of basic deterrence theory, right? You know that you're not catching all of the bad conduct, and so you have to impose some additional penalty, some punishment. And of course, criminal law is all about punishment.
But do you see that in your research, Brandon?
It is typically from what we know about these cases, and sometimes they just don't explain it. But when they do explain it, it looks like it's not really a punishment. They're not having to give back all of their gains, or they're not having to give something extra back.
You know what it looks like to me? It looks like the feds are getting in on the profit making that the corporations are engaged in.
Well, so
like, give us a little kickback, and we won't prosecute.
Here's too big to jail concern number 2. So one response is that they say, well, look. The people who did the crimes aren't paying these fines anyway. It's the shareholders, it's consumers that may pay. Fining isn't the best way to put a stop to this behavior, but we have other tools. What we can do is force the company to change its practices, monitor the company, rehabilitate the company to make sure it doesn't happen again. And that is really important. They say, we're going to put people in place. We're going to make sure that they change the way that their employees are compensated, to change their incentives so that they won't break the rules again. If that was working, that would be way more important than that would prevent crime. And
But we're not seeing that as a result.
Well, yeah, and unfortunately what I found looking at the terms of these agreements, often the terms are just, do some best practices for 2 years and report back to us. It's just sort of like, okay, so you're going to depend on their say-so. When, the reason why you're prosecuting them is that their compliance and their systems were so bad that you think finding them isn't enough, you have to do more, and yet you're just going to say, get back to us. There's an amazing drama unfolding right now in the Eastern District of New York. Judge John Gleeson has said that HSBC, which was prosecuted in perhaps the worst money laundering type case, but they had sanctions violations. Basically, money was going through HSBC to all of the places in the world where it wasn't supposed to be going. I think there was a series of Homeland episodes with a fictitious version of this. It was sort of ground zero for dark money, going to terrorist organizations, Mexican drug cartels, you name it. They get a deferred prosecution agreement, so no conviction. No employees are prosecuted. But there is a monitor for 5 years who's supposed to be an independent person to supervise rebuilding their compliance. And what the judge ultimately said was, I want you to tell me as the judge, I'm not a potted plant here. Tell me what's going on with this. And the very brief reports that the judge was sort of summarizing suggested that compliance was going really, really badly. And lo and behold, I think a shareholder, a member of the public, petitions the judge and says, I'd like to know what the entire 1,000-page monitor report from this last year says, because I want to know what's happening at this bank. I think the public has a right to know. This is of public concern. This is a government case. What is the Department of Justice's interest in keeping this secret if this bank that committed such terrible crimes, they admitted it, isn't fixing the problem? And the judge said, you know what? I agree. I'm going to make it all public. And everyone is scrambling to object. And he says, yeah, of course, there may be some confidential employee information or some stuff that has to be redacted. But in general, I think that this is of public importance. And I agree with the judge. I don't understand why these reports aren't always made public. But I think that these are public interest matters. It's all been swept under the rug in the past, though. And so it's amazing that it took a bold move by a judge to suggest that what happens in one of the big corporate prosecutions of all time should actually be public, and we should actually be able to read what's going on. But normally the company pays the fine, they sign an agreement, we're going to do best practices, we'll fix things.
And it's all secret. And
then 2 or 3 years later, there's a note from the prosecutors in the company saying, we're satisfied with the conclusion of this agreement. And yet some of these companies have been prosecuted more than once, sometimes several, sometimes 3 or 4 times in a period of a short number of years, including actually in particular the financial institutions, the banks that the public is so upset about. And so that really suggests these aren't working right if you have these recidivists that are doing it again and again and again.
It's like the bank robber that keeps going back to the same bank, and the government refuses to arrest him. And the government refuses to make him give his money back.
Well, and the banks in their defense can say, well, we're not recidivists because we've never had a criminal record. We got a non-prosecution agreement, then we got a deferred prosecution agreement. Right? We've never been convicted. Now you're starting to see banks actually get convicted, and that is one way that the Department of Justice has started to respond. The banks for years were saying, if you convict us, we'll get shut down, we'll lose our charters, all of the people who have their savings with us will lose their money. It'll be terrible for the economy. You just can't convict us.
We're too big to jail. Yeah.
Yeah, we're too big to jail. Literally, we're too big to jail. And the prosecutors actually went to the regulators and said, well, if we convict them, can we have some assurance that they're not going to lose their charter, but that they'll be, watched over? And the regulators said, oh, yeah, that's fine. So now the banks are pleading guilty, and the prosecutors are insisting on that. So they do have criminal records. If they do it again, it could be a breach of probation. Normally, right, it's not just that you could get prosecuted again, but you get a recidivist sentence. It's a breach of probation. All sorts of consequences flow from doing it again when you're on probation and have a criminal record. It's true for individual people. And increasingly, hopefully, it'll be true for corporations.
We're talking with Brandon Garrett of the University of Virginia School of Law. His books include Convicting the Innocent and Too Big to Jail. There is some good news here, I guess. There are some positive changes. Are they ever really going to prosecute individuals, like some of the men and women in the boardrooms who are making these decisions and profiting off of them?
Well, that's been one of the biggest criticisms, and it's one of the things I described in my book as just a fundamental problem with these cases. You don't want the corporation to be like the scapegoat, this artificial scapegoat that you can't literally put in jail that would let its shield its officers or employees from criminal accountability. But I looked at these deferred and non-prosecution agreements. About 1/3 of the time, employees are charged. Many of them don't get any jail time And a lot of them are lower level employees that you're sort of like, well, why are they picking on them? They weren't the ones calling the shots. And so I've been a major critic. I'd like to think someone was listening. Judge Rakoff has been a critic of this. And this fall, us critics, are a small band of critics, we feel like, oh, they're actually listening. The Department of Justice announced changes to its policy, saying that from now on, Sally Yates announced this in a big speech, and then they changed their actual guidelines in writing to say that the focus in a corporate criminal investigation from the very beginning will be on individual wrongdoing and who did what. And of course, my response was, really, you didn't do that before? This actually had to be said. But clearly it did, because the company would say, oh yeah, people committed crimes, but apparently no one was really looking too carefully into who did it and who did what. And actually, I wonder what's going to happen now that they say it's a priority. Well, I mean, they would sometimes say it was a priority before, and so now they're saying it again. What does it mean for them to say it's a priority?
Yeah.
There aren't any dollars behind it, because one reason it was understandable that you'd sometimes say, okay, company, pay $1 billion and we'll call it a day. Well, it might take years to figure out who at HSBC, actually approved and who knew. When you have like hundreds of people who are all working on this and different people were signing off and they had lawyers signing off and accountants, it takes a lot of work. It could take an enormous team to go through all the documents and to investigate something like this. And do they, just because they say it's a priority, what's there to back up that priority? What are the corporate strike forces that are going to actually start taking on these cases in a systematic way? I worry that they say it's a priority, and now we're going to spend lots of time investigating who did what. What if that means that these cases take years longer? And what if the corporation gets off the hook because the investigations drag on for so many years that prosecutors ultimately give up? So I don't know how this is going to play out. I worry that it won't accomplish what it's supposed to. I am glad that the Department of Justice is finally listening to critics and rethinking what it's doing. But I worry that there's a real, these companies hire entire law firms to defend them in the big cases.
Yeah.
I talk in my book about the Siemens case where they spent over $1 billion investigating themselves, hiring lawyers. A lot of that was to turn themselves in and tell the prosecutors exactly what they did. But there's just a vast legal team spending, just armies of lawyers and specialists working on their defense and on their investigation.
Let me ask you this, Brandon. We've been here before in the American story where we had huge corporate interests that got too big, and the federal government has consistently stepped in and said, you know what, you've gotten so big that you're violating everything we purport to stand for as a free people. You're violating our ideals of justice, of law, of capitalism and constitution, and so they break them up. Have we gotten to a point in our story where we need to break up the banks? I mean, there's only like 4 or 5 big banks now right out there that used to be dozens and used to have real competition, but now they're just beyond massive.
Well, it's interesting. I mean, some people think that it's actually the very same regulations that are protecting. They're being passed to prevent crises and prevent crashes in the markets that are encouraging the banks to consolidate. That, in fact, our response to the last crisis is causing further consolidation in the financial industry. And because, we want the banks to have more reserves and to be less risk-taking. And I'm not an expert in finance. I have no idea whether that's true or not. It does seem to be a fact of modern life, though, that lots of industries are being concentrated, not just banking, but the law firms that our students work at. You didn't see like law firms with 1,000 partners before. A big firm big firm had like 80 lawyers or 100 lawyers.
Right.
And
that consolidation across these industries manifests itself in some couple of really unlikable things that we could just say are corruption. Regulatory capture, rent-seeking economics. That's corruption. It violates free market capitalism. It violates competition. It's not capitalism. It's corporate socialism.
They're having a big event on regulatory capture in the Senate next month that I'm going to, and it's a sad statement that they're inviting a criminal law guy like me to a regulatory event, a regulatory capture event, because you think, okay, maybe regulatory agencies that work with industry and are thinking about industry rules, maybe they could get captured because they're depending on information from industry. But once it's a crime, the idea that you could capture prosecutors, and these are aggressive prosecutors who really do want to win big cases. I do think that a lot of the prosecutors in these cases are impressive people who are doing their best.
But they're operating within an environment where it's not just one hand tied behind their back, but it's two.
You don't normally think of prosecutors as the little guy in any kind of a fight, but even when they do bring individual cases, they go after. It's rare to see a CEO prosecuted or a top officer at one of these companies. Those cases often go to trial. In regular criminal cases, they mostly plead out. Millions and millions of dollars may be spent on defense lawyers, tens of millions. I mean, one of these white-collar trials may cost more than the public defense of an entire federal public defender's office.
Just for one trial.
Just for one trial. And so, and maybe that's good. They win some, they lose some. But, it's good to have cases tested out in the courts. No one should have a problem with that happening. But it highlights just the gulf that separates people who are charged who are of modest means. People ask, how many white-collar criminals there are. Well, it's hard to know because a crime like fraud or defrauding the federal government, right, there are thousands of people prosecuted every year for those crimes. And their crime was like they resold, $200 of food stamps or something like that. And, they don't have $1 million lawyers and minor money laundering cases. People get severe sentences for pretty minor financial crimes, which you can't even call them white collar. These aren't people working for corporations, or if they are, it's like, false billing, $10,000 to Medicaid or something like that. Yeah. And then at the other end of the spectrum, you have these multi-billion-dollar schemes, and maybe the same crime, but
it's on such a big scale.
But it's on a global scale.
So what do you say to somebody listening, Brandon, who's thinking, well, why care? Why regulate this at all? Why don't you just leave these businesses alone to do what they're doing? And that's capitalism. Government should get out of the way, and right. They shouldn't prosecute or regulate these things at all. What's really at stake here?
And I even agree with a lot of those criticisms that there are too many things that are crimes in this country, and a lot of these businesses say, why treat it as a crime? If we break rules, then fine us. I think some of these really serious corporate crime cases that prosecutors have brought in recent years, I disagree with how lenient the settlements are, but some of these cases really show how important it is to treat some corporate misconduct as crimes. You take the GM case last year. There's been a lot of criticism. No individuals were prosecuted, but over about 130 people died, and these were defects that you could say, well, they violated safety rules. That's civil. But no, it was a crime because they didn't tell the regulators that this was happening for years, and people were dying. There were even people, I study wrongful convictions, people wrongly convicted because they got convicted of vehicular manslaughter, and it turns out, no, the car really was defective. It wasn't anything they did with the steering. And so these are, or the coal mining disaster in West Virginia, or HSBC, right? Money laundering with money going to terrorist organizations, hundreds of millions of dollars going to the Mexican drug cartels. We know about the violence that's going on in Mexico. If you were financing or enabling the financing of those drug cartels, much more serious conduct than the biggest drug kingpin in Charlottesville may be inconsequential compared to the managing that kind of money and letting that kind of money flow to the cartel. So these are crimes of enormous public significance and concern. I'm glad that some of these corporate crimes are treated as crimes and not just petty violations, but I'm also relieved that we're starting to see more conversation around how can we take them more seriously.
Yeah. So what can a citizen who cares about this kind of stuff? What's our role? We don't run corporations. We don't sit on these boards. We often feel powerless as we look back and we ask our government, why aren't you enforcing the law here? What can we do?
Well, we also we don't elect our local U.S. attorneys, the federal prosecutors that bring these cases. Now, our state attorney generals sometimes bring big corporate cases, and so you can write to the attorney general and say, why don't you can get involved in these cases too. But I think it's going to matter a lot who our next attorney general is. And
so elections matter?
Elections certainly matter. And even the political pressure, just people yelling and screaming that too big to jail has got to stop. I mean, when Loretta Lynch took over from Eric Holder as Attorney General, immediately, right, the Department of Justice sought to distance itself and say, look, we're going to change some of these policies. We're going to take this stuff seriously. I really do think that, although we don't directly elect the Attorney General, they're appointed through the Senate, but they're very sensitive to criticism.
What crosses your mind when you look out across this year's presidential race? On one end, you have Bernie Sanders saying we need to stop too big to jail. We need to go after the criminals on Wall Street.
He's saying it, and I think it's really important to have strong statements like that. I've been really impressed. The Clinton campaign has a really detailed plan describing all the changes they want to make to how we prosecute corporations. They're not saying it in the fiery way that Sanders is, and I was waiting, but he released a plan having to do with corporate crime too, but it didn't say very much about the criminal prosecution side of things. But I think a lot of the energy and concern on the Democratic side of the spectrum is that whoever the next president is, they have to do more about corporate crime, and I think that's a really healthy thing. Of course, the Republicans aren't saying anything about it at all. It's just been total silence on that topic. And so,
since what, the 1870s?
Right. And so, although, actually, the W. Bush administration, I think maybe especially because he was personal friends with Ken Lay and these Enron executives, or they wanted to distance themselves from that. And so they said, oh, no, we're forming an Enron task force. We're going to prosecute these people. That was sort of the beginning of this modern DOJ approach towards corporate crime, and maybe it was just because it didn't look right that W. Bush had gotten so many campaign donations and was so buddy-buddy with the Enron types.
Yeah. So where should we leave this? There's room for hope, but there's a lot of work left to be done.
I think it's the approach towards prosecuting corporations has changed so much in the last 15 years. The Department of Justice, they're moving away from these out-of-court deals, these deferred prosecution agreements. They're starting to insist on convictions. They're starting to say we're going to hold individuals accountable. Every once in a while now we're seeing them prosecute a CEO, like in this coal mining case in West Virginia, the Massey coal case, where Don Blankenship was just convicted.
What was your reaction to that? Was it the right thing based on what you know of the evidence? And
it sounds like they showed there was a real culture of ignoring safety rules.
Yeah.
But it was a big deal. It's rare to see a CEO prosecute. They spent years building that case, and they had lower level people who pleaded guilty and cooperated and described what he had told them. It also helped that they came out through insurance litigation. He was taping his office. It was like the Nixon tape, so that they had lots of evidence on tape.
Yeah.
And often you're not going to have that. It's a real challenge to show, because the person at the top can say, I'm just focusing on the bottom line. I read some reports. I don't know whether there are safety violations in the mines. I don't go there. I'm not a worker. I don't see that stuff. I have no idea. It's a real challenge to bring cases like that. But I think public really has to stay on top of this. Be writing politicians. We're now seeing something. I think it's really important that they're considering federal sentencing reform on the Hill. But one of the provisions that they've been batting around is what they call mens rea reform, where they want to make it harder to show that higher level executives like Don Blankenship, they want you to have to show intent, so that they intended there to be a crime. And for some crimes, you don't have to show intent. So Don Blankenship was convicted on a misdemeanor, so he can't spend too much time in jail, but at least he gets a criminal conviction, assuming he was guilty and knew it. But you didn't have to show he intended that there be an explosion in his mind, or that he intended and ordered directly people to do safety violations. It was a misdemeanor, and so it's they could show that he was just negligent or reckless. I think it's a recklessness statute. Anyway, this mens rea reform that some of the corporate interests are pushing, and some of the senators are saying, we're not going to agree to federal sentencing reform unless we include this too. It would say that basically normally the standard should be knowledge, that you have to know that what you were doing was illegal, and that a reasonable person should have known it was illegal. And so to create sort of a reasonableness defense for these executives who can
Sounds like an out.
Yeah, they can say, it's a very complicated issue of accounting law or securities regulation, and other people were doing it, so I reasonably thought that it was okay. It would be a real significant out for executives, and it's intended, sounds like, to be kind of an out for executives. It's not really a reform at all, but Obama said he would veto something with that. A lot of the Democrats are saying that has nothing to do with sentencing reform. You're just trying to add an out to countless statutes, because it would apply to all across federal crimes.
But that would apply to these very powerful interests that, as you point out, if they abuse this kind of power, people die. I mean, this is real stuff we're talking about. And yet, if you talk about somebody who involuntary manslaughter, drinking and driving, they put them in jail and throw away the key. They don't get the out.
And this is what's happening on the Hill, right? There's a sentencing reform that would allow reduce sentences for nonviolent offenders. It could affect thousands and thousands of people who shouldn't be in jail at all, little people who can't afford real lawyers. Huge numbers of people would benefit from this sentencing reform, and it's all being held up because of an effort to try to insulate top-level executives. And that crystallizes the too big to jail problem with this country.
There you go. Yeah, there's no better illustration than that right there.
Yeah.
And so the fight continues. And that fight is, let's be very clear, do we use the power we have in this country to move towards our ideals or away?
Well, and also it's a nice illustration of how these ideals can be distorted. Right? This is about reforming over-criminalization. That's why we need to make sure that no one gets convicted of a crime unless they did something that was unreasonable. Yeah. Well, I guess they figure they can rest secure on the idea that, the things that executives do, that seems very reasonable. It's all about business decisions. It's very complicated. Whereas if it's like some minor drug offense, that's unreasonable. No one should have drugs. If it's some other nonviolent violation or even some minor violent crime, you should be able to hold that person for years and years. Tough federal sentencing because that's unreasonable behavior. These big corporate cases where decisions are made in boardrooms can affect the savings of every American. They can affect the economy. They can cost huge numbers of lives, and the crimes just aren't treated the same way.
Brendan, thank you for being here. Appreciate your time and all the work you do.
Thanks so much, Coy.
You've been listening to the Citizens Band Radio Hour, a production of the Center for Media and Citizenship at the University of Virginia. Archived podcasts are available online at mediaandcitizenship.org. The executive producers for the program are Siva Vaidyanathan and Coy Barefoot.